Morning, everyone. Welcome to Alternative Workweeks, Required Steps and Considerations. So this training is sponsored by the Central Valley Regional HR Hotline. My name is Anna. I'm the Digital Media and Event Strategist here at the California Employers Association. And again, we just want to thank you for spending your morning with us. Before we get into today's training, just a couple details to go over with you, especially if this is your first time in a training with us. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during the training. If you do have any questions about the content, you can put those into the Q&A box at any time, and we will address them as we go. While we have one trainer, Juliana, delivering the content, we'll have Virginia managing that Q&A box, so you'll be in great hands today. Handouts will be dropped into the chat box, shortly. So once you see that PDF icon and file name pop up, you can click on it and it should download locally to your drive. I'll be watching the chat box the entire time. So if you have any trouble accessing that PDF, just go ahead and message me in the chat and I'm more than happy to get them to you in an alternate way. As you saw when you logged on, this webinar is being recorded and the team over at Central Valley will be reaching out when it is available for review. And then also, last but not least, we will be inviting you to share your feedback at the end of today's training by participating in a very brief survey. So it's only 5 questions, takes about a minute to complete. But the feedback that you share with us in those 5 questions, we really do take to heart here at CEA. And we just want to make sure that we are meeting and hopefully exceeding your expectations with trainings like these. And this is also your opportunity to suggest trainings that you'd like to see in the future. There's a field for that also. So we really encourage you to share that. Now I'd like to introduce our trainers today. We have Juliana Gabriel, our Senior HR Compliance Director, who is going to be delivering the content. And again, we have Virginia Young, our HR Compliance Director, managing the Q&A. So you are in great hands today, and I will give it over to Juliana.
Thank you, Anna. Good morning, Central Valley employers. We're very excited to have you join us today. I have to say that the Central Valley is near and dear to my heart. That's where I grew up and where my family is still located. So welcome. I also do want to give a big thanks to the Central Valley counties that have sponsored this event today. And I want to remind you that they provide Central Valley employers with a no-cost HR hotline. So if you are in the counties located over here to my right, you can take advantage of this HR hotline. And how it works is you can call in Monday through Friday from 8 to 5 with your HR questions. And you will always get a live HR advisor, such as myself, Virginia, one of our colleagues, to help answer your HR question. So that could be on the topic of alternative work weeks or another wage and hour topic. Maybe you have some questions about breaks and lunches or overtime. You want to get it right in California, or maybe some questions about administering a leave of absence, your options to provide paid sick leave, hiring, firing, and processes, all of those types of things. We can assist you. So please, if you haven't called into us before, call into the hotline and we are happy to assist you with your HR question. All right, so now I'd like to introduce California Employers Association, or CEA, for those of you who are just joining us for the first time. We are an HR consulting company and we have members located throughout the state of California and beyond. And our goal is to provide you peace of mind with exceptional HR compliance solutions. So if you find you do need some additional HR support beyond the hotline provided by the Central Valley counties, you can join as a CEA member. That would give you access to our extensive library of forms and policies and toolkits. So for example, we have a toolkit all on alternative work weeks with sample forms and toolkits on a number of different topics. We can also help you out with projects. So if you need us to work on a customized employee handbook for you, come and conduct an HR audit or do some training for your staff, assist you through a workplace investigation, we can help with all of those types of services. So we have our website listed here, employers.org. You are also welcome to call our main line listed there if you would like to get more information on memberships or the type of services that we can help you out with. All right, now I do want to note that this presentation today is for educational purposes only and should not be relied upon as legal advice. So CEA is not a law firm, and we cannot give you legal advice either when you're calling into that HR hotline or on these types of trainings. But as Anna mentioned, we're more than happy to answer your general questions about the content today. We want to make it as useful and practical for you as possible. So please direct those over to the Q&A box. Virginia's in there and she's going to be assisting in answering your questions today. So please make use of that. All right, so let's talk about what is on our agenda. What are we going to be going over today? Well, first, we're going to kind of demystify the concept of the alternative work week in California. So, what is it? What is the purpose of it? And what are the different options in establishing an alternative work week? So, we'll give you an overview of that and why employers choose to implement it. What are some of the benefits for employees as well? And then we'll talk about the required steps to actually implement an alternative work week schedule. I can't tell you how many times I've gotten a phone call from one of our employers on our hotline, a well meaning employer that says, yeah, we have a 410 work week. We have an alternative work week schedule. We just decided to start scheduling that way and we don't pay overtime. And then they don't know that there's actually very specific steps that they have to go to establish that alternative work week schedule, including an election, reporting results to the DIR, to avoid some of that daily overtime. So we have to be really careful there because if we don't go through that process, then we have potential overtime penalties that someone could come after us for. We're also going to talk about some different wage and hour considerations. So, how it does impact overtime pay. It's going to be a little bit different if you have an alternative work week schedule. You're going to have some different rules to follow. And we're going to also go over, well, what's the impact on meal and rest breaks? What about reporting time pay? So, just giving thought to all of those types of issues. And then some frequently asked questions, ranging from how do we handle this if we have a new hire that's joined us after we've established an alternative work week schedule? What if someone's requesting an accommodation because they don't want to work the schedule? We will answer all of those questions for you today. All right, so let's start with what exactly is an alternative work week schedule in California? So it is any regularly scheduled work week requiring an employee to work more than 8 hours in a workday. And the reason that this is significant is it's going to allow us to avoid some daily overtime that we would otherwise have to pay. That's really the whole purpose behind an alternative work week schedule and the reasons an employer might choose to implement that. And another really important point here, this is only relevant for your non-exempt employees because those are the folks that are entitled to overtime pay. For your exempt employees, it's really irrelevant. We can tell our exempt employees what hours we want them to be available to us. So, for example, if we want them to work a 4 day a week, 10-hour schedule, Monday through Thursday, and be available at those times, we can tell them to do that without a problem. Because exempt employees, as a reminder, they're paid for the skill they bring to the job, and they're not paid based on the hours they work for us. For most exempt employees, they're going to be paid their full salary for the work week if they perform any work in that work week. That's the general rule. So this is really relevant to our non-exempt hourly employees. Now, what is the pro for the employer? So if you implement an alternative work week properly, you can actually avoid some daily overtime requirements, up to potentially 10 hours that someone could work without incurring any overtime. And you might say, well, if you are looking at daily overtime requirements in California, it's due once they work over 8 hours. So you're really only saving on 2 hours maybe. But that's a lot if you think about it, per employee per day. And if it makes more sense for you to have a longer, uninterrupted shift, that can be a huge cost savings for the employer. And we'll talk about, I'm going to use that 410 example a lot because it's kind of the easiest alternative work week to understand. It's one of the most common, but we'll also talk about some different types of schedules that you could come up with in an alternative work week schedule. Now, what's the pro for the employee? Well, employees get to work a compressed schedule that allows for more days off. So, for example, if they do work, let's say that 410 schedule, Monday through Thursday, they're working 10-hour days, and then they get Friday off, let's say, they could potentially take on another job and earn more income. They could use that for personal time, to plan things to do with their family, or maybe just catch up on chores before the weekend. Less commuting time, potentially, not having to drive to the office an extra day and spend the gas money. So there's a lot of benefits for employees, even if they're giving up some of that overtime. A lot of employees really love it because it allows for more flexibility in their schedule. Now, what is an alternative work week not? So it's not a flexible schedule. And how that has been defined is when you have different schedules available to employees. So, for example, working the AM shift or the PM shift, that's known as a flex schedule. where they get to choose what time of day, but they are still working generally 8-hour days or they're incurring overtime. So alternative work week schedule, again, refers to that regularly scheduled work week that's going to require an employee to work more than that 8 hours in a work day. All right, so now let's go over the overtime requirements in California, and we'll talk about, again, how an alternative work week does or does not impact that. So as a reminder, under most wage orders, you need to pay your non-exempt employees time and a half their regular rate of pay when they're working over 8 hours in a workday. That's known as daily overtime, and again, that's really what's relevant here to the alternative work week schedule. Also, we have to pay 1.5 times regular rate of pay when they work over 40 hours in a work week. That's weekly overtime. And adopting an alternative work week schedule does not change that. So if someone still works, 41 hours, 42 hours in an entire work week, we're going to still owe that overtime. And then for the first 8 hours worked on the 7th consecutive day in a work week. So in California, we have this 7th consecutive day rule, and it really depends on how you define your work week. So the default is Sunday through Saturday. It's always going to be a 7-day period. But some employers might choose to make it Monday through Sunday. And so when you're looking at that 7th consecutive day, if you're a Monday through Sunday employer, you're always going to be looking at that Sunday to determine whether they worked that 7th consecutive day and they get that overtime. But if you're Sunday through Saturday, then it's always Saturday that you're going to be assessing. So it really depends on how you define your work week. And then in California, we also have double time. So we have to pay 2 times someone's regular rate of pay when they work over 12 hours in a workday. And then if they work that 7th consecutive day and they go over 8 hours, then that also kicks into double time. So really, we're only looking at this daily overtime requirement that's going to change. And then we're going to have some additional requirements that we're going to talk about in terms of overtime if we do adopt an alternative work week schedule. All right, so let's go over some of the different types of examples and how you could establish an alternative work week. So we have the 4-10 schedule that I've been referring to, and that is a work week in which employees work 4 days, 10-hour shifts per day. So that could be Monday through Thursday, could also be Tuesday through Friday. An employer can choose a regularly reoccurring schedule. Then you have the 3-12 and 1/4. So what does this refer to? So this is a work week in which employees work 3 days, with 12-hour shifts, and then they work 1 day, that's a 4-hour shift. And you'll notice we're still within 40 hours in a work week, but we're going to potentially avoid, again, some of that daily overtime. Then we have the 4-9 and 1/4. So that's a work week in which employees work 4 9-hour shifts, or 4 days, 9-hour shifts each, and then 1 day, that's just a 4-hour shift. So kind of similar to the example we just went over, but broken up a little bit differently. There's also a 980 schedule, and that is when you're stretching out basically 80 hours of work over a period of 10 days, and the employee is going to get 1 day off in a 2-week period. So just to give an example of what that would look like, maybe Monday through Thursday are each 9-hour days, and then Friday they work an 8-hour day, and then the following week, Monday through Thursday are 9-hour days, and then they would have the Friday, that second Friday, completely off. You have to be really careful in how you define your work week. If you want to adopt a 980 schedule, I would really recommend that you consult with legal counsel about that. It's kind of the trickiest to establish because what could end up happening is, depending on how you define your work week, you could still end up incurring some overtime with 4 hours of overtime in 1 week because you're going into 44 hours potentially. But if you're able to break up the work week at what some employers do is at a Friday at noon, for example, they can push the other 4 hours into the second work week. So it's okay if you didn't follow me on that. It's pretty tricky, but we would recommend that you consult legal counsel if you're going to use a 980 alternative work week schedule. All right, so let's go over some of the ground rules in establishing an alternative work week. Number 1 is that not alternative work week schedule requirements are exactly the same for every employer. So you're going to always want to refer to your IWC wage order. So if you're not familiar with what that is, in California, every employer will fall under an IWC wage order, or their employees do, based on their industry or occupation. So it's really important to know which one applies to you. We have a great link here, this bit.ly link. You can copy and paste that into your browser. And it is a guide from the DIR on determining which wage order applies to your employees. And really, this is something that should be printed up in your workplace. It's a multi-page document. So we usually recommend just putting it on a binder ring and hanging it up next to your labor law poster, for example. But you're going to want to refer to that for your alternative workweek rules. So just to call out some specific exceptions, or some exceptions for certain healthcare employers with what they can establish in terms of an alternative workweek schedule, and also under wage order number 16 with certain construction workers. So make sure you're always, as a first step, checking the wage order that applies to you. Now, with our alternative workweek schedules, just like the schedules we just went over, you can establish a schedule that's up to 12 hours per day on a regular basis. So like the example where we had those 3 12-hour days and then the 1 4-hour day. But remember that overtime is still going to be owed when someone works over 10 hours in a workday. So you can have that regularly reoccurring 12-hour workday, but just remember, once you go over 10, we're still paying overtime. But you are avoiding a couple hours potentially, because remember, the default rule is when someone goes over 8 hours in a workday. So that's potentially up to 2 hours per employee per day that you're saving on overtime. And remember, we're going to still owe that weekly overtime and that 7th consecutive day overtime as well. Also, we can't stress this enough. There are specific steps that are required to implement an alternative workweek schedule, and we are going to go over all of those in detail with you. And that includes a 2/3 vote by the affected work unit to make sure that you actually are going to be able to avoid those daily overtime requirements. Another really important point here is that alternative workweek schedule must be regular and consistent. So we can't do something where we implement an alternative workweek schedule, let's say that 410 schedule, and just say, you know what, this week we're just not going to work it. And we decide week to week whether we're going to work an alternative workweek or not. That is not what the DIR intended with their regulations. So it's really important that if you decide to implement it, that it makes sense to do so on a long-term consistent basis. If you start to kind of go back and forth and not follow the schedule, there could be an argument that you owe overtime, that you have been required to pay overtime because you're not actually following that alternative workweek schedule. So you could be opening yourself up to a lawsuit if you do that. So make sure it actually makes sense for your organization. All right, so now we're going to jump into the 6 steps to implement your alternative workweek schedule. And we're going to unpack each of these further. So step 1 is going to be proposing a written schedule to the affected work group. We'll talk about exactly who that is in the affected work group. And we also need to hold a meeting with that group. And at the time of the meeting, provide a written disclosure on how the alternative workweek schedule is going to impact their wage and hour rules, their benefits, and those types of things. Then in step 3, we're going to hold a secret ballot election at the workplace. It is anonymous. Step 4 is we're going to report our election results to the DIR. And then we're going to prepare to implement the schedule and then actually create the schedule. So as I mentioned, if you are a CEA member, we have sample forms for all of this in our alternative workweek toolkit that you can refer to for some additional help. All right, so step 1 is the proposal. So you need to designate a readily identifiable work unit. So you need to establish who is going to fall under this alternative workweek schedule. It does not have to be your entire organization, but you do have to be able to define a unit. You can't just pick and choose certain employees that it's going to apply to if there's nothing that's kind of connecting all of them and bringing them together. So you could do it by a division or a department. So you could say the HR department is going to be under an alternative workweek schedule, or the safety department. You could also do it by job classification. So it might make sense to put your foreman all under an alternative workweek schedule. You could do that. You could do it by job class. By shift time. So if you're a larger organization and you do have different shifts, maybe you want to do it for the morning shift, that they work maybe a longer shift. And so that makes sense for them, but doesn't make sense for the afternoon. So you could do it by shift time. You could also do it by physical location. So maybe your location here in the Central Valley, you don't want under an alternative workweek schedule, but you have another location in the Bay Area and you want that location under alternative workweek schedule. You could propose it by the different geographic location. In certain cases, you could actually also have one individual employee under their own alternative workweek schedule if they truly qualify as their own identifiable work unit. So what do I mean by that? Usually where we see this come up is if they truly are one of one in terms of their job classification, there's no one else that's in their same job class, then maybe it does make sense for that one person to be under their own alternative work week schedule. But again, we can't just have a handshake agreement where we just decide that we're going to start working that schedule. If we want to avoid that overtime, we have to make sure that we go through the steps. So then after you've decided who is the affected unit, and remember, again, this is only going to be non-exempt employees. It's not relevant for our exempt employees. So once we've established that group, we're going to distribute the proposed written schedule to the affected units. And we are going to identify what is the regularly scheduled AWS that we're proposing. So maybe you are doing the 980 schedule or the 312 and 1/4 schedule, or you can provide a menu of options. So it is okay if it's regularly reoccurring, that you have, for example, that maybe 1 week they work 4 10s and then they work 5 8s, but it has to regularly reoccur that employees can predict their schedule from week to week. What the DIR doesn't want to see is that employees really don't get the benefit of the alternative work week schedule and being able to plan around that. Say, yeah, I can take on that another job, or I can go on that family trip, where we're constantly changing things. But you can have some different schedules that are regularly rotating, so that's okay. Now, we do need to identify the number of work days and hours, but at this point in time, you don't have to give the specific like shift start and end times or the specific days of the week. So it could be sufficient to just say we want to adopt a 410 alternative work week schedule. So 4 days a week, 10 hours a day would be fine to identify it that way. All right, step 2 is we're going to hold a meeting and provide a written disclosure. And we do have specific timing requirements here. It needs to be at least 14 days prior to the employee's vote. You could extend it, further from that, but at least 14 days you have to give them from the time of the vote to attend this meeting and to contemplate it. And you're going to hold this meeting for the affected employees. So if you selected that department or that entire location that it's going to apply to, you're going to hold the meeting for those folks. And we have to disclose to them how this is going to affect their wages, hours, and benefits. So we'll talk about that a little bit more in a minute. But obviously, a big one is this is going to impact how overtime is paid. That up to 10 hours a day, you're not going to be earning overtime, that daily overtime anymore. Really important also that you train your managers or supervisors that are involved in this process that they cannot coerce anyone to adopt or vote in favor of the alternative work week schedule. There also can't be any sort of adverse action against the employee. So let's say they have a dissenting opinion at the meeting, or they raise their hand, they say, I think this is a really dumb idea. They can't face any sort of adverse consequences for that. So disciplinary action, demotion, changing their pay rates for if employees don't adopt the schedule, or saying, if you adopt it, we're going to pay you more. We can't do that. You also need to provide a written disclosure outlining how this is going to impact wages and benefits. And that needs to be in English and also in the language spoken by more than 5% of affected employees. So let's say you have Spanish speaking employees in the group, you're going to also want to provide that disclosure in Spanish. And then any employees who could not attend the meeting, maybe they were out sick that day, we're going to mail the notice to their address on record. All right, so we need to ask ourselves, how will the alternative work week schedule change any sort of benefit entitlements? Because then we need to let employees know about that. So again, we're going to need to outline how the overtime requirements are changing under the AWS, but also be thinking about how this might be impacting holiday pay or vacation sick leave accrual and usage. So for example, let's say you do have a 410 alternative work week schedule that you're going to adopt, and a paid holiday falls on a work day. Your handbook might have said before that when someone's paid out a holiday, that it's paid on the basis of 8 hours per day. But maybe now it makes sense to change that in your handbook to paid on the basis of 10 hours per day for those employees that fall under the alternative work week schedule. So it aligns with their work day. You might also want to think about vacation and sick leave accrual. They are potentially accruing a little bit more now per day because they're working more hours. But if they're working the same hours within a total week span, they're still working their 40 hours, then it should generally shake out about the same. But just be thoughtful about how that may impact things like holiday pay and accruals and usage, how much time you're deducting if someone takes a sick day on their alternative work week day, for example. All right, step 3 is that secret ballot election. So the alternative workweek schedule has to be adopted by at least 2/3 of vote of the affected employees in the work unit. So they have to vote in favor of it. And again, you can't allow exempt employees to vote or anyone else that is not going to be subject to the alternative workweek schedule. So it's only for the affected employees in the work unit. And this secret ballot election needs to be held during working hours at the employee's work site. So it is working time. This means that it's also compensable time. So we're paying the employees for their time as they're, including at the meeting, right? The meeting that we held with them and also for the vote. And we have to cover all costs as the employer. So printing the materials, the distributing the notice, we have to handle all of that. Now, you might be wondering, well, what if someone returns a blank ballot or maybe they don't return their ballot at all? The regulations are very clear that that is counted as a no. So you might want to inform folks of that, that if you don't turn in your ballot, that it's going to be counted as against establishing an alternative workweek schedule. So again, we have to have a 2/3 vote in favor, and it's anonymous. So we're not going to have employees' names or ID numbers on that ballot, but you can have some sort of system so you can track that you've received the ballots back. So you could assign everyone like an anonymous number, 1 through 50, so you can track which ballots were returned as long as they are not tied to a specific employee. All right, step 4, and this is really important. You have to report your election results to the DIR, and it's specifically the Office of Policy and Research and Legislation. And the deadline to do that is within 30 days of the election happening. And that report to the DIR will become a public document. Now, it's not going to have any sort of identifying information regarding how anyone voted, nothing like that, but it is a public record that anybody can look up online to see if that employer has established an alternative work week schedule. Now, with respect to the ballots and all of your internal documentation that you don't need to send to the DIR, I would recommend that you maintain all of those records for your protection. So if there's ever a dispute whether overtime is owed, you have a few different ways of proving, you have your results reported to the DIR, but you also have all of your documentation establishing that you did get that full 2/3 vote, that you went through the entire process. So I would recommend holding on to those records, honestly, as long as you have the alternative workweek schedule in place. And even if you repeal the alternative workweek schedule, I would still hold on to those records for at least 4 years, if not longer, because someone could bring a wage and hour lawsuit for up to 4 years back. So those records are your protection. So I recommend holding on to them. All right, now in terms of what information we need to include in our letter to the DIR, it's pretty basic information. So the name of your business, street address, city, county, state, zip code, the nature of your business. There's really no definition specifically for that, but you can kind of just intuitively decide what makes sense. Are you a restaurant? Are you in agriculture, manufacturing? Provide the nature of your business. Date of the election, so the date that you held that vote, and then the date that you're sending that letter to the DIR, that you're mailing it off to them. Again, it should be within 30 days of each other. A final and full tally of the vote. So I would recommend putting the number that voted in favor, the number that voted against, or was a blank ballot, and then the percentages there to show that that was a 2/3 vote. And then they want the total size of the affected work unit as well as the work schedule. So for example, that 4-10 alternative work schedule. Now we're going to make it really easy for you here because we have the very specific mailing address provided. So it's at the attention of the alternative workweek election results. And we have the DIR's PO box here for a PO box in San Francisco. And really important tip is after you mail that letter to the DIR, you're going to want to go to the database and verify that the elected schedule is on file. As we just went over, This is a public document, so you can always look up to see if an organization is under an alternative workweek schedule. So we have, again, a bit.ly link here you can put into your browser, and I would always recommend checking that, because let's say you notice that it's not there. You don't want any sort of argument that you did not correctly establish your alternative workweek schedule, because what that means is you're going to have potentially a claim for unpaid overtime. Now, let's say you've already adopted your alternative workweek schedule and you decide to go check it out today and you can't find your organization listed there. Usually we get that question, well, what do I do next? Now I can't find my organization. We recommend first, make sure you've typed in all of the information correctly regarding the organization's name. It might be that you have a DBA. So first, kind of do your due diligence with that to make sure you've kind of filled out your information properly. But let's say you just really cannot find your organization listed, I would try to go back first through your records to kind of see what happened. Can you find proof that that letter was mailed to the DIR? And then I would consult legal counsel about what the best strategy is for addressing that issue. It's always a good idea when you're just not sure of the status to get some legal advice. You don't want to go immediately into a panic. A lot of the times issues can be corrected and resolved, but that is what our recommendation would be if you can't find yourself listed there. All right, step 5, we're going to prepare to implement the schedule. Now, we cannot require employees to work that new schedule, even if everybody voted in favor, until at least 30 days after the announcement of those final election results. So once we announce how the election went, we have to give employees 30 days before we can force them to work that new schedule. Now, employees may voluntarily work the schedule sooner. I'd probably get something in writing that they're voluntarily deciding to do that, just because, again, we don't want any sort of argument that you didn't go through the steps properly. And again, check that AWS database prior to actually requiring employees to work the schedule. And then step 6, we're going to actually create the schedule. So in advance of employees beginning to work, they have to know the actual work days and shift times. So this would be the time now that we need to tell people we're going to have a regularly reoccurring schedule of Monday through Thursday from 8 a.m. to 6:30 p.m. if we're putting the meal break in there. And then we have to set that going forward. It has to be consistent and reoccurring. What the regulations say is we can have occasional changes as long as we're giving advance notice at least 1 week. But again, it needs to be very occasional. If we start frequently making changes and not following the alternative workweek schedule, as I mentioned, we're opening ourselves up to potential overtime claims and penalties. And as I already talked about, you also can establish an alternate and regular and reoccurring schedule where you're alternating through weeks of, let's say they voted for a 410 Monday through Thursday, then Tuesday through Friday, as long as it's regularly and reoccurring. So they know, okay, this is the Friday I'm going to have off. This is the Monday I'm going to have off. They need to be able to have that heads up. It can't be a way of having on-call employment and work through this alternative workweek mechanism. And Virginia, do we have some questions we can get to now we got through all these steps?
Yeah, we have one question in the Q&A that I thought would be good to answer live. And the question is whether alternative workweek schedules can be used for part-time employees as opposed to, or is it only reserved for full-time employees?
So it can be used for part-time employees that have a regularly and reoccurring schedule. So if they're more on call or working varied hours, then it really wouldn't make sense because you can't have them in a consistent schedule. But if they are working, let's say, only a few days a week and there are those longer uninterrupted shifts, it might make sense to have it for a part-time employee. Do you have anything else to add to that, Virginia?
Yeah, I agree. The important thing is to make sure that they are actually regularly working more than 8 hours a day as part of the alternative workweek schedule, because that's how it's defined. So if you have them working long days 1 week and then a short day the next week, then I think that might be more problematic. Yeah.
Right.
So good question. And then another question that I get often on the HR hotline is what should we do if employees are not able to come to the election, can they vote, if they're not able to appear at the work site? This came up a lot during COVID. And there wasn't a really good answer to this that we could find in the regulations, but eventually, after contacting DIR a number of times, it seems to be that it's really important that they physically be there. So you really have to do everything you can to make sure that employees are able to physically get there and vote.
That's a really good point. And as a practical matter, it might be good to kind of survey the affected work unit to see when most people are going to be available, because you don't want a situation that everybody's out on leave. Maybe it's summer break or it's graduations, right? And it's kind of a bad time. So maybe try to get some intel on when would be a good day and provide maybe some alternative dates to choose from so you help avoid that issue. All right, great questions. Well, we will continue moving right along, and Virginia will be in that Q&A for you. So you might be wondering, can we repeal the alternative work week schedule? And the answer is yes. It can be done either by employees or by the employer. So by employees, what has to happen is there needs to be a petition of 1/3 of affected employees. So again, the employees that are under the alternative work week schedule, they need to make a petition. And then you would have to hold a new secret ballot election that must ultimately be approved again by 2/3 vote to dismantle that alternative work week schedule. You need to, after a petition, if you get that 1/3, hold the election within 30 days. But there is a special rule if you've just, let's say, adopted your alternative work week schedule in the past year. There is a requirement to have an interval of at least 12 months between the adoption and the repeal election. So you could decide, no, we're going to give it this first year. Let's get everybody kind of used to it. And then once we get through the first 12 months, then we can hold that election again. So that provides some protection to the employer. If you've just established an alternative work week schedules, employees can't immediately dismantle it. Now, let's say they do vote in favor of dismantling it, then you need to comply within 60 days and stop the alternative work week schedule. Now, you, the employer, can repeal it unilaterally without employee approval at any time. A lot of employers are very surprised to learn that. And I think this makes sense because really the DIR and California want to protect employees and being paid overtime. So they're less concerned if you're going back to our regular overtime rules and getting rid of the alternative work week schedule. Now, the law doesn't specify how much notice you have to provide, but we recommend 30 days would probably be considered reasonable. But there's really just not a bright line rule on that when the employer is unilaterally getting rid of it. All right, so a little pop quiz here to move us right along into our wage and hour considerations. Our AWS is a 4/10 Monday through Thursday schedule. This week, our employees also worked a 10-hour shift on Friday. What is owed for Friday? So this is going to get us into our special overtime rules if you work an alternative work week schedule. And as we're going to learn, any day that's worked outside of the schedule, so here the Friday, the first 8 hours is at time and a half, and then after that, we kick into double time. So that's a special rule that we don't have right under our regular overtime rules that we have to be aware of with an alternative work week schedule, that when employees are working in excess of the schedule, we're often looking at that overtime. So we are now going to go over the unique overtime rules if you have an AWS, and also talk about how it impacts meal and rest breaks as well as reporting time pay. So here are our overtime requirements if you have an alternative work week schedule. You need to pay time and a half someone's regular rate of pay for all work performed in any workday in excess of the regularly scheduled hours established by that AWS. So let's say you have that 3/12 and 1/4 schedule, that 1 4-hour day. But let's say the employee worked 6 hours that day. And you might not be thinking about overtime, right? Because it's still a pretty short day, but we're now in excess of that alternative work week schedule. So those additional 2 hours need to be paid at time and a half. And remember, we still have weekly overtime. So all work performed beyond 40 hours in a work week is going to kick us into overtime at time and a half. That doesn't change. We must pay 2 times someone's regular rate of pay for any work over 8 hours on days other than those regularly scheduled by the AWS. So a non-AWS day, just like on our example with that Friday that someone worked. Again, the first 8 hours is at time and a half because that's in excess of the regular schedule. And then any work over 8 hours is going to kick you into double time on that day. And we still have our same double time rule here. For any work that ever goes beyond over 12 hours in a workday, we always have to pay 2 times someone's regular rate of pay. All right, what about this situation though? Our AWS is a 410 Monday through Thursday schedule. On Monday, we only needed our employee to work 9 hours instead of the regular 10 hours, and we sent them home early. What is owed? So you might be thinking, well, you're within your 410 schedule, you're under it. So does this really change anything? And the answer is yes, it does when it's the employer who is changing the schedule. Anytime an employee is required to work fewer hours than they normally would under an AWS, you must pay overtime after 8 hours in a workday. So put another way, basically, if you send an employee home early, your daily overtime requirements, the regular overtime requirements, are just going to kick back in. Now, if the employee chooses to clock out early, then only straight time wages are owed. So it really makes a difference if it's the employee that's saying, hey, I need to go pick up my kid from school. Can I leave early today? Then those overtime requirements, those additional overtime requirements wouldn't kick in. So of course, a best practice is anytime that happens where it's the employee asking for that, make sure they put their request to leave early in writing so it's really clear that you didn't owe them the regular overtime that day for the schedule being too short, for it falling short of their regular schedule. All right, let's talk about meal breaks, rest breaks. How does the alternative work week impact them? The answer is it really doesn't. It doesn't change our rules, but you do need to be careful if you've been having your employees work a regular 8-hour day. You might not realize, depending on the alternative work week schedule, how many meal breaks or rest breaks they're now entitled to. So that's really the main point you want to be careful of, that you're providing enough meal and rest breaks. So as a reminder, we need to permit a minimum 30-minute meal break if an employee works more than 5 hours in a day. And that meal break has very strict timing requirements. It needs to start before the end of the 5th hour of work. So what that means is the employee needs to be clocking out to begin their meal break by 4 hours and 59 minutes into the shift. So that doesn't change with an alternative work week schedule. We would still recommend you're scheduling that first meal break at the 4-hour mark or 4-hour and 30 mark, so we don't have a situation where they run late due to work. Then we're going to owe premium pay if we don't provide a sufficient meal break. That's 1 hour of pay at someone's regular rate as a penalty. So if you do have, let's say, a 410 schedule, if they are within exactly 10 hours or less, then you are still only going to owe that 1 meal break. But if they go over by just a minute or two, remember, we're now looking at 2 meal breaks. Or let's say you establish those 3 12-hour days, you're always going to have 2 meal breaks that are going to be required. Anytime you go over 10 hours, we have that second meal break requirement kick in. Now, what about rest breaks? So we need to authorize and permit rest breaks. They need to be in the middle of each work period. So we can't tack it on to the meal period. We can't put it at the beginning of the workday or the end of the workday. It has to be in between. Also, they're paid. So they're on the clock time. So we don't have employees clocking in and out like we do with the meal period that is unpaid time. And what is required is 10 minutes of rest time for every 4 hours worked or major fraction thereof. And again, if we fail to provide a sufficient rest break, if it's the fault of the employer that the employee didn't get to take it or that it was too short or interrupted, we're going to owe that 1 hour of premium pay. So here, taking a look, again, an AWS does not change rest break requirements, but you're going to want to check how many are owed. If you're looking at a regular 8-hour shift, it's 2 rest breaks. And with a 410 schedule, it is still 2 rest breaks. Again, if it were exactly at 10 hours or less, 2 rest breaks. Once we get over 10 hours, though, we're going to kick into that 3rd rest break requirement. All right, now what about reporting time pay? So employees, remember, in California are owed reporting time pay when they report for their regular shift and they work less than half of their scheduled shift. They must be paid at least half of their scheduled hours in that case. But remember, we have this rule that it never can be less than 2 hours and it doesn't need to be more than 4 hours of reporting time pay. So it's good to know that an alternative work week schedule does not change that maximum. So you may have someone that, let's say, works a regular 12-hour day or a 10-hour day, but you would only be owing them a maximum of 4 hours of reporting time pay, not 5 hours, because we do have that rule that it's a maximum of 4 hours. So this is some good news, is you don't have to worry about it really changing your reporting time pay requirements. But again, anytime someone works less than their regular schedule, you do need to be thinking about those additional overtime requirements that are going to be kicking in that case. All right, so let's now jump into some frequently asked questions, and then we can also close out with some of your questions going to the Q&A. We're going to talk about accommodation issues, how you handle it with a new hire. What if someone wants to substitute their schedule or make a switch in their schedule? How do we go about that? And then if you're a larger employer and you're sending employees to different work locations that may or may not have an alternative work week schedule, how does that all shake out? So we have an employee that voted in the election. They said that due to childcare obligations, they cannot work their newly approved alternative work week schedule. Do we have any obligations to accommodate? And you might be thinking no, because as a general matter, childcare obligations under a lot of circumstances, we don't always have to accommodate. But whatever the issue is, it could be related to their pet, or maybe they're caring for a family member, or they have another job. Do we have to accommodate them? And the answer is yes. To an extent, we actually do. It does provide this in the regulations. You must make a reasonable effort to find a work schedule that's not going to exceed 8 hours in a workday to accommodate any affected employee who was eligible to vote and can now not work the new schedule. So, what are some ways you could accommodate someone? You could offer the employee to work 4 8-hour days, for example. Let's say you adopted that 4-10 schedule and they just can't be there for those last 2 hours. They're going to have a little bit less in terms of their hours per week and their pay potentially, but that would be a reasonable accommodation in this case to allow them to just work their 8-hour day, those 4 days a week. Or if you're able to, you could offer to transfer the employee to a different department or position that does not have an alternative work week schedule. So there's a few different options, but you do want to show that you try to make good faith efforts to accommodate someone who just can't work the new schedule. As opposed to just saying, okay, goodbye, you can leave our employment now. So make sure you document that process. All right, but you might be wondering, what if we hire a brand new employee into a work unit that adopted an AWS? They didn't even get an opportunity to vote in the election. Can we apply it to them? And employers are often surprised that the answer is actually generally yes. Generally, you can apply it to a new employee. We don't have the same accommodation requirement where we have to try to find them an 8-hour-a-day schedule if they were hired after the election. But it's still really good and best practice when you're interviewing candidates to inform them, hey, this position would be subject to an alternative work week schedule. Are you able to work this schedule? Because it's best for us and them that if they can't, they filter themselves out. And we're not, going through all of the process of onboarding them, getting them ready to work, and then we find out they can't even work the schedule. So make sure you're addressing that as you're interviewing candidates. Now, you are permitted to accommodate a new hire if you want to do so, but you're not obligated under the law to do that. Now, an employee is requesting to substitute 1 day of work in their regular schedule for a different day outside of the AWS. So can we allow this? And the answer is occasionally, but you want to proceed with caution on this. So whenever it's at the request of the employee, you can allow them to substitute 1 day of work for another day of the same length. So maybe they say, we work Monday through Thursday. This Monday, I have to go take care of a personal obligation. Can I work a 10-hour day on Friday instead? And if it's at the request of the employee, it's not you, the employer, changing the schedule. You can do that on an occasional basis without incurring overtime. But again, you want to be able to prove that it was at the request of the employee. So make sure to document the request to indicate that it was them asking for that. And also don't make it a regular practice. So unfortunately, the regulations do not clearly define what they mean by occasional. So we're kind of left to guess what they mean by occasional. I would say if it's happening a few times a month, that's probably more than occasional. Maybe a couple times a year, I would think you could make an argument that's fairly occasional. The reason is we don't want a situation where it looks like we have a regular practice of not following our alternative work week schedule, and that we ultimately, there's a claim that we owe that employee those overtime, unpaid overtime potentially. All right, so true or false, you must reasonably accommodate an employee who cannot work the AWS due to a religious belief or observance. Let me know in the chat what you think here. True or false? Is this something that we have to accommodate? Right. Let's see what the answer is here. So the answer is true. We do have to accommodate if someone has a religious belief or observance. So let's say you have a schedule where employees are working Saturdays or Sundays, and someone is under a religion where they have to observe the Sabbath, or maybe they have certain daily prayer requirements. We are going to have to accommodate that unless it would cause an undue hardship. And remember, undue hardship is a legal standard. It's very difficult to satisfy. So in these types of situations, we recommend that if you get an employee that's coming to you and they say they have a conflict or an issue with the schedule due to their religion, we would recommend that you consult with legal counsel before you terminate that person or consider it a voluntary resignation if they don't work the schedule. All right, so what if an employee under an alternative work week works at a different location? Maybe you have multiple locations and that location doesn't have one. So what is the rule then? Generally, the AWS would not apply to that different location. So if that employee is going to a location that doesn't have an alternative work week schedule, they are just working a regular work week with their regular overtime rules that apply. So even if they are under an alternative work week schedule at their other physical location, it wouldn't apply when you're sending them to a location that doesn't have one. Now, what about if an employee that is not subject to an alternative work week schedule goes to a location that does have one? They're generally not going to fall under the alternative work week schedule. We would generally apply our overtime rules, but there is one exception to that. And the exception is if an employee is normally not under an AWS, but they work at a location that has one, if they're told in advance that that different location has one and they work at the location for one or more full work weeks, then you can subject them to the alternative work week schedule. If it's only a couple days, that's not going to count. It would have to be for the entire work week. Then you can apply the alternative work week schedule and not pay that daily overtime, for example, if they were informed in advance. Again, I would put that in writing for your protection. All right, Virginia, I'll let you pop in here so we can also get some of our Q&A questions answered.
Great, thanks, Juliana. We have one outstanding question in the Q&A about what the effect of the alternative work week might be on the employer's sick leave obligations under California law.
That's a great question.
It's a really good question. I had some immediate thoughts on it. The first one is if you're using a lump sum sick leave policy where you're giving people 5 days of sick leave at the beginning of every year, that standard is 5 days or 40 hours, whichever is greater. So if you have an employee who is working a 10-hour day, 5 days really means 50 hours, not 40 hours. If you are using an accrual basis for your sick leave, employers have to worry about a cap on accrual because that sick leave carries over every year. And the accrual cap has to be at least 10 days or 80 hours, again, whichever is greater. So your employee working a 10-hour day, their accrual cap, 10 days would be 100 hours, not 80. So you might have to make some changes there if you have an alternative work week. And then finally, when employees use their sick leave, if they normally work a 10-hour day, they should be able to use 10 hours of sick leave for a full day that they're gone. Those were my immediate thoughts.
I think you answered it perfectly, Virginia, and I think that's a great question. So I concur with all of that.
Great. I think that's the only open question in the chat at this time. But
okay.
Yeah.
Well, you can submit a few questions. We have a little bit of time if you need to, but otherwise I want to remind you that you do have the Central Valley hotline that you can call into if a question comes to mind later today. We'd be happy to assist you on that as well. And for those of you, again, who need maybe just a little more support beyond that hotline, there are options to join CEA as a member, and you can get access to all of our toolkits, including that alternative work week toolkit. And also, depending on the level of support you need, we can help you out with projects, get your employee handbook up to date, help you out with those leave policies, and crafting strong and compliant policies for you. So please reach out if you'd like more information on that. But otherwise, I will turn it back over to you, Anna, to help close us out today.
All right. Thank you, Juliana. Thank you, Virginia. So much information in less than an hour. I don't know how you guys do it. But if you are joining us for continuing education credits today, I have those codes for you in the chat as well as seeing them on the screen. So your HRCI code 704956. SHRM code 25-7QYF7. CEAinfo@employers.org. If you need some guidance on what to do with those codes, where to put them for certification or recertification, we're happy to guide you through that process, or go ahead and call that, that HR hotline, and we're more than happy to walk you through that. And then we do have, excuse me, that that survey that I did mention at the top of the hour. So if you scan that QR code, or once you click out of Zoom, a browser window should pop up. All you have to do is click opt in. But again, it just takes a minute to a minute and a half, and it's only 5 questions. And this is how you suggest future topics that you'd like to hear. This is how you share feedback about the training itself. So we'd really love to hear your feedback if you can take a minute at the end of today. And then I did want to draw your attention, if you haven't been following in the chat, a couple of things. The next webinar coming up is on June 26th. That's going to be California leave laws. Again, that's sponsored by the Central Valley Regional HR Hotline. So make sure to click through to that link and register after we're done here today. And I think that's it. So unless there's anything outstanding that anyone has, I think our chat looks clear. So what do they say? We'll give you your 2 minutes back. But I want to thank you, Juliana and Virginia, for sharing your time and expertise today. Thank you all for joining us live and bringing your questions and engagement today. And again, thank you to the team over at Central Valley for sponsoring today and for bringing the complimentary HR hotline collective to Central Valley employers. We look forward to seeing you on June 26th for the next training, and we'll talk to you soon on that HR hotline. Thank you, everyone.